Property Law Association Roundtable on Streaming Media and Broadband. We have a distinguished panel this evening. Meryl Johnson, our media rights, will be moderating. She's a professor of intellectual property classes here at Brooklyn Law School, and was my professor. This evening, you need to make sure to fill out your participation certificate and give it to this lady over here in the red blazer. Otherwise, you won't get your CLE credit. You are obligated to stay for this 2 full 50-minute session. And in the middle of the round table, we will have a short break so we can change the tape on the video channel. And so right now, please welcome Meryl Johnson.
Good evening, and thank you for coming to the law school. I think that one of the important parts of today's program will be participation by the audience in asking about the panel members views on your issues and the issues that they've raised. I think that the notion of the roundtable discussion certainly implies and seeks participation from the audience. I do have a great pleasure in participating in this roundtable because Susan has gathered together a collection of people who I think are really quite knowledgeable about the important emerging issues in the law. Today's program will start off with Eric Schmidt, who is, if I'm correct, non-lawyer on the panel. And he is here to help us understand the new and emerging technologies that are the subject of today's program. Mr. Schmidt is currently with a startup organization, MySportsGuru.com, which provides applications, which is an application service provider, providing infrastructure for multi-tier organizations. Prior to that time, he worked with ESPN and Stargate Wave Corporation. And it's done a substantial amount of work in developing websites for sports-related companies. So it's with great pleasure that I welcome Mr. Schmidt. You can put it there on here. I'm not sure if you can put it down.
There you go. We want to start with the wrong definition of what dropping the practical terms is basically 100 kilobits per second rate. Right now, today, it's basically got a cable modem for DSL into your home and beyond. Most people in their office place have a T1 connection, a cable modem or a DSL line generally runs about 100 kilobits per second. A T1 line is about 15 times as fast as that, or 1.5 megabits per second. Just as a point of reference, a typical MP3 file, which most people are downloading off the internet these days, runs about 7 megabits. So in a perfect world, on a T1 connection, you'd be able to get an MP3 file now in just under 10 seconds. In terms of adoption rates, currently there are about 3 million people who have access to broadband to their homes. If you factor in the total number of people that have it with their workplace as well, that figure is well over 10 million people at this point, with the number in 2004 expected to reach over 30 million people. Right now, there's basically, we've got 3 different types that can allow you access to audio, video, and data and two-way communications within your home. Cable modems, currently, even if you aren't using a cable modem, if your set-top box allows you to use pay-per-view, so you can just click on the remote control, you're effectively using broadband communication because you're using a secondary data stream going back upstream. And I say that's important because there's currently active development on set-top boxes for you to be able to receive the internet synchronous with your audio and video at the same time. The second way is DSL, which is basically a fatter phone line into your home, dedicated circuit between you and your phone company that allows you to achieve a higher data rate. The third being a T1 connection, which is an actual full dedicated circuit. And you can receive rates that are just about the MPEG-4 current video rate. Just to stop for 1 second, MPEG-3, or MP3, as most people know it, is really just a file format. If you use Microsoft Word, the file format is DOC. But MPEG-4 is a file standard that Microsoft, that AT&T, that Intel, as well as the cable companies have all sat on and sorted that this is the file format that we want to deliver. So when you hear about companies like Napster, they actually write MP3. Really what they've done is they've facilitated the download of MP3 by making it faster. The real players in the broadband space, obviously Microsoft is huge, but they basically stayed out of accelerating the speed at which you can download these files because it runs counterintuitive to their business model. They want to sell more hardware, they want to sell more software. It's not their business to be allowing people to receive audio and video in their homes. Then you've got some of the road companies like Napster and like DivX that have come out with ways to make it easy for you to get audio and video into your homes. Napster facilitated a thing called MP3 by not actually storing those MP3s, but by finding two people, one person that has an MP3 on their hard drive, another person who wants an MP3, and connecting the two without actually going through Napster. That's important because Napster basically got shut down, not for delivering MP3s to people, but facilitating communication between the two people. There's another format out there called EPSF that is the latest thing register, which allows you to encode DVDs. And a couple of companies have popped up to allow you to do that as well, one of them being DivX. And the thing about both of these companies is what they've done is they've offered up their code for free. So it's not just these companies that are doing it. As soon as they put it out there, effectively anybody who knows how to program can go out and get those codes, and you can burn your own CD-ROMs, you can have your own audio and video, and you can share that with anybody around the world. So just basically wanted to give a background for some of the challenges that broadband are offering. Also in concert with that is simply how you folks that own these properties receive their money back for creating them. If you create a 2-hour movie like The Matrix, and all of a sudden somebody has figured out a way to distribute this movie without paying any money back to the people who own the rights to that property, it's concerning. One of the ways that it is possible to track down the folks that use the means of distribution over the internet is by basing whatever you do by your IP address. Everybody who connects to their internet service provider has an IP address. So everybody has a unique number when you use your computer. The concern in doing this is that as soon as we identify a number with you every time you use your computer, we can, as a computer, we can track whatever your behavior is online as well. And that has broad-reaching privacy implications. That as soon as I can do a thing called a trace drive and figure out who you are and what you're doing online, the concern is it doesn't necessarily just have to be concerned with people that are ripping off MP3 videos or DVDs online. So whatever measures are used moving forward, need to have that consideration that people need freedom of their own privacy as well.
Thank you. Our next speaker is John Norman, who is an expert in intellectual property law. He practices litigation practice at the law firm of Mintz, Levis, Cohn, Ferris, Giusti, and what else? Entails patent, trademark, and copyright issues. So He'll help us with the intellectual property process.
Nice to see you all. We talked about shortening the names of MITS 11, but much easier in programs like this. What a difference a year makes. I don't know if any of you were here last January when I spoke about the rise of the business methods patents in reaction or as a sequelae to State Street. That was a different time. We were at the height of the gold rush, and there seemed to be no end in sight to business method patents and what could be patented. Things have changed in the last year, and I will go through that in my talk today. Just a quick review of what happened in 1998 and 1999, the State Street case, which most of you would be familiar with, held that business methods are patentable. It's basically established that proposition. And as a result of that case, there was a flood of applications and patents granted by the United States Patent Office. The number of applications in the business methods area grew from some 700 in 1996 to over 2,500 in 1999. Some of the more prominent ones you may be aware of are the Walker Digital patent, which was basically the Priceline patent, which essentially patented the notion of an online auction. And of course, a year ago, Walker Digital and Priceline were flying high. That's not the same story today. I also pointed out last year that things like a process for determining the dates ranging from 1999 to 2000 was patented. The old Y2K problem, which we were all very concerned about a year ago. The Federal Circuit, in its AT&T Excel case, applied State Street principles to method patents as well and continued the acceleration, the acceptance of business methods patents. Probably the most dramatic thing that happened just at the end of last year, dramatic from the standpoint of a patent lawyer, is that the court in Seattle, after reviewing the patent that Amazon had received on the one-click concept, the one-click purchase concept, after a relatively short motion for preliminary injunction hearing, issued an injunction against Barnes & Noble from using the one-click method for its website. This was remarkable in many ways. It's quite difficult to get an injunction, preliminary injunction in patent matters. Almost never happens. And the court basically reviewed the validity issues, the infringement issues, and was particularly impressed by the argument that if there was no injunction issued because of the tenuous nature of the internet market and the upcoming Christmas season, that unless it got its injunction, Amazon's business would go down the tubes. Now, Amazon has had problems, and it may not have been as a result of this because they were successful in that case. Other things that came up in 1988 and 1999 was the fact that there was a lurking British telecom patent which basically covered the whole notion of hyperlinking, which is probably the most essential feature of the internet. What happened since then? During the year 2000, as my paper indicates, there has been a backlash. The backlash is basically a result of widespread concern about the proliferation of business methods patents and what effect that will have on business generally. I divided this into a variety of different places where that backlash has come from. The first of which is the Patent Office itself. In March of 2000, the Patent Office promulgated what it called a plan for business method patents, and is now treating those in a way that's different than the way it treats regular patents. It now has instituted a second level of review by a senior examiner for patent applications in the business methods field, something it had not done before. It has also made it a requirement of examination in business method patents that the examiners review not only material in the Patent Office itself, but material outside of the Patent Office. Another reaction to to the proliferation of business method patents was in Congress. Two congressmen, Messrs. Berman and Boucher, had introduced a bill which is quite radical in its implications for patent law. What they provide in the bill, which only applies to business method patents, is a variety of things that are foreign to normal U.S. patent prosecution. For example, as most of you may know, a patent application is not published in the United States. It's published after 18 months of filing just about everywhere else in the world. In the United States, applications are confidential until the patent issues. This bill would require business method patents to be published after 18 months. It would also give the public an opportunity to comment on the disclosures in the patent application and basically allow a period of public protest. The applicant would have to disclose as part of the application process whether they had conducted a patent search and what they turned up in their search. Again, this is something that is not done in the normal course of patent prosecution. There would be a presumption that the invention was obvious if all it entailed was the application of computer technology to a previously known business method. The notion of a presumption of obviousness, again, completely turns patent law on its head, where usually there's a presumption of validity. And finally, the bill would require that to establish invalidity of a business method patent, all that the opponent would have to establish is preponderance of the evidence that the patent was invalid, as opposed to what now is the standard, and that is proof by clear and convincing evidence, a much higher standard for invalidating patents. This bill is in committee. I think it is unlikely that it will pass, but it reflects great concern, and I think that perhaps pieces of it may resonate, and we may be seeing modifications of it somewhere down the road. The marketplace, of course, has also played a role. This is a very interesting story, which some of you may not know. Jeff Bezos, the principal of Amazon, although he was successful in getting an injunction against his private competitor, Barnes & Noble, has taken and has used the patent process to his advantage, has publicly stated that he thinks that the patent law that's currently drafted stifle competition. And what he's done is he has funded a new venture, which was announced in the fall of last year, called Bounty Quest. And what Bounty Quest is a private firm which offers bounties of up to $10,000, sometimes more, for people who can find prior art out there which may be used to invalidate patents that are the subject of litigation. And if you go to the bountyquest.com website, you can get a very clear description of what they're looking for a whole host of biotech, mechanical, and design patents. And if you have in your garage a piece of art or whatever, some design that you're aware of, you can be rewarded for that. There's an interesting subtext to all this, which is and again, it's very early in the game, but if companies engage in this Bounty Quest process, a possible drawback is that they may turn things up that they don't want to know about. Because not only may they not turn up things that will be helpful in terms of fighting off whoever it is they're trying to fight, but they may turn up things that they will then have to deal with with respect to the products that they currently make. There is also another very active site called buspatents.com. And if any of you are interested in getting at least one author's views of those patents out there that should never have been approved and are very weak and vulnerable, that's a good place to look. The reason I mentioned Europe on the outline is because there is a difference in the law in the United States and Europe on the issue of business method patents. Europeans have been much slower, they're much more conservative on the notion of allowing business methods to be patented. And there actually is a disparity there because the U.S. company could go to Europe and pick up a good business method idea, which is unprotectable in Europe, bring it here and seek a patent on it here. Most people who evaluate the relationship between European patent law and U.S. patent law feel that the two systems will come closer together as time goes by. It's more likely that the Europeans will start to adopt a business method approach more like our own. There is a lot of concern about the fact that the patent office continues, notwithstanding the controversy I mentioned, to allow patents that are overly broad and don't seem to make much sense. And the reason I mention In Re Side here is because In Re Side is an old case in which the patent office, sua sponte, decided that a mechanical patent, which just had an ornamental feature added to it, was not patentable. Some commentators have suggested that what the patent office ought to do is what Congressman Berman's bill suggests, and that is in those inventions which basically take a pre-existing known method of doing business and apply computer techniques to it, those patents should not be allowed by the patent office. Finally, I'd like to talk a little bit about the courts. The courts, the Federal Circuit, which is the court, basically the court that decides most patent cases in the United States. The Supreme Court occasionally takes patent appeals, but most cases in the patent arena are decided by the Federal Circuit. Has not been terribly helpful in terms of stemming the tide of broad business methods patents. There was a case decided in October, and it was a case decided by Judge Jones, a very good, I don't know if he's related to Harold Jones. Barbara Jones is a very good Southern District judge, and she was confronted with a patent that clearly came before the internet. That is, a patent involving a method by which people could, at a retail location, get a copy of the tape made on the spot. The idea was, the patent was back in 1985, the idea was that instead of having to warehouse things like CDs or LPs or whatever, they could be produced at a retail location. The patent claims themselves were very broad, but the specification made it fairly clear that this did not apply to the internet, where people on their PCs at home were downloading MP3s. Barbara Jones, in looking at the specification, looking at all of the material in the patent, reached the conclusion that this was not a valid patent. It did not apply to the internet. The Federal Circuit, in a very, very, very long and carefully worded and complicated opinion, basically took the position that notwithstanding the fact that the specifications appeared to be dealing with something that predated the internet, and this was not an internet-related invention, believed that the claims were broad enough to include what the defendants in this case were doing, that is, people who were selling things over the internet for downloading purposes. So the Federal Circuit has taken a fairly expansive view of the business method patent. So I don't think anybody can count on the Federal Circuit to kind of cut back. So the final thing I'd like to mention is that the notion of getting preliminary injunctions continues. Just a couple of weeks ago, a company called Net Zero got a preliminary injunction against Juno Online with respect to an advertising, a patent relating to the dissemination of advertising in Windows on a website, which is an injunction that was issued just 3 weeks after the patent was read. So the courts are prepared to enforce internet patents and construe claims broadly. Thank you.
Thank you very much. Our next speaker is going to talk about copyright and trademarks. She's Nicolena Haley, who is the Senior Counsel on Artifacts.
Vice President, Senior Counsel, Intellectual Property.
So you could have done that. Hi, thank you.
Hello. Copyright and trademark infringement on the internet is a huge subject, particularly for those of us who've been deputized with protecting copyrights and trademarks in a content-based company like Viacom. Earlier we heard about the threat to assets which we consider our core assets, namely copyrights on the internet through mechanisms such as CCSS. I worked for Viacom for 7.5 years. When I started, we had barely heard of the internet. A few years ago, when we came out with Titanic, Five Below the Paramount Pictures, there was a big hoopla around the company that within 3 days it was available online. But then we started a theoretical problem because it took 24 hours for anybody to be able to download it and see it. It's very difficult now. So, however, the internet, the enforcement problems not only threaten our core assets through worldwide, widespread infringement, but it also threatens our ability to exploit the internet. If we cannot be certain that our core assets are going to be protected, then we're in a very difficult situation in using this incredibly powerful tool that is available to all of us. And the technological advances make it a moving target. So we may feel comfortable today that we can encrypt our material, but we don't know what tomorrow is going to bring. Earlier we heard about Napster, the battle between the big content owners who are trying to protect their monopoly and the notion that sharing is fair, that experience under the copyright law, come on, why can't we share? Query whether is supplanting the need to pay the owner by making what that owner has created widely available for no money is fair, or whether owners and artists will in fact be able to or be willing to continue to create content if there's no way to pay for that content. And there's a historic note that is of interest. In post-revolutionary France, they decided that it was that copyright and the monopoly was an unfair tool of the aristocracy, so they abolished copyright for 3 years. During that time, no works of any real import were published, and basically only gossip magazines were available in France because they realized that if there was something with any shelf life, it wouldn't be protected. So after 3 years, they brought back the bad copyright laws. Can you tell where my position is? So we're faced with a lot of difficult issues, not just the basics of copyright law and the basic rights and wrongs, but the worldwide notion of the internet, the decentralized nature of the internet. Napster is a group that we can identify. Nutella is not. Nutella doesn't even have a central organization that you can sue, yet they're out there circulating our audiovisual and music works all over the world. I outlined in more detail the case law, so I don't think it's worth taking everything's time right now. But suffice it to say, I mean, we've got, it's easy for me to minimize Napster's arguments, but David Boyd found that words to represent Napster in an appeal. Napster won below, but a stay was granted. The Ninth Circuit still hasn't made a decision on on whether Napster is not liable under the fair use laws, which is a major argument that Napster put forth, that there is no market harm, that they are able to facilitate the sharing, or maybe indeed that the copying that is being conducted is not infringing. An older case, the Betamax case, found that private copying of television shows through your VCR for your own personal use is not even a copyright infringement, and the Napster folks and other similarly situated companies are trying to expand that finding to the world of the internet. The trademark realm is slightly more defined, amazingly enough. I never would have guessed that a couple of years ago. Domain name and use, third-party use of domain is the basic headache of trademark owners on the internet. The Anti-Cybersquatting Act of 1998 was full force this past year, and it proved to be a powerful tool against those companies which essentially warehouse a long laundry list of famous marks, registering them as domain names, and sitting there waiting for the trademark owners to come to them. They were able to circumvent the classic trademark laws by effectively arguing that merely registering without putting up an active site didn't constitute trademark use, and so they were able to avoid the classic trademark infringement claim. However, trademark owners pointed out that if their trademark domain name was taken by a third party and kept them from being able to exploit it in the related realm, then it was sufficient harm to warrant legislation. The anti-cybersquatting law also gave in-rem jurisdiction so that I can go after somebody who has registered with NSI in Virginia, even if that entity is in some far-off land. I can bring them into court in Virginia. And the UDRP, which was set up by ICANN, the governing board for domain name registration, provides online arbitration, cheap, simple. You file essentially something between a complaint and a summary judgment motion outlining their position on why you believe that a third party has registered a domain name that rightfully should belong to you. They respond, and a decision is rendered. No discovery, no replies, except in extreme circumstances, and no hearing. Similarly, there's worldwide jurisdiction. You have to agree to the jurisdiction of the UDRP if you file registration with any of the major top-line domain name groups. And so that has been a powerful and inexpensive tool for the clearly bad faith infringements of the world. It's got limited jurisdiction. It's not going to take care of the gray areas where both parties have arguable trademark rights. But if you've got a real pirate out there, it's a quick way to take care of it. So I guess the story that we all have to keep in our heads and keep in mind going through in the future, at least from my perspective, is that to some degree the laws must evolve to meet the technology and the new facts of this world. But we who are charged with using those laws and using that technology also have to recognize that there are new business models, new legal models that we're going to have to live with in order to exploit the exciting world of the internet.
Thank you, and I think that leads us to the next part of our program, when we're talking about business activity. And our first speaker is Lois Sandbeck, who is Vice President of Legal Affairs of Scripps Network. And he'll talk with us about alliances and partnerships in this area.
Thank you. I'm going to take a little different approach for my presentation. And what I have done, I think everyone has a copy of the outline that's prepared before. what I've done is set up a fact pattern that I can use to illustrate the issues that are set forth in that fact pattern. So I'm going to probably do a little bit more reading than I'd like to, but as I go through, you get a sense of what I'm trying to do. The other thing is that I may sound a little schizophrenic as I'm reading it. The reason being, what I've done is, in my fact pattern is make each of you representative of a company that's on the other side of the table, and I'm by myself representing the other company. And I will be saying what I think you're thinking, or what you want to do, so you don't have to actually participate, but I want to put in your mind a frame of reference to work with me through these points. Okay, you represent Home Video Inc., a syndicator of home video footage. Your client's goal is to make as much money as possible through license fees while giving up as little of its rights as possible. Your risk includes the possibility that the cost of being engaged in this business, including administration, personnel, conversion costs, and the limitations that may be imposed on your company in terms of your rights, may not justify revenue stream and may not also justify the branding that you hope to get through your engagement in this area. Also, your client is concerned about the technology. What happens if something goes wrong? Who's going to be responsible for that? And what your potential is in terms of revenue, we have no idea. I represent Conduit.com, a portal that streams video content over the internet. Its goal is to make, of course, as much money as possible, with as much content as possible, and using it in as many ways as possible, and if possible, limiting the competition of using the content. For my client, the risks associated with business include possible infringement suits, minimize profit due to competition from old, current, or developing technology, and more. It may deny it, but my client realizes that content is still king. And what its business will or may not be is going to depend on the nature and the quantity and the quality of the content is able to stream through this technology. Now, Content.com wants clearly defined rights in the video that's being provided by Home Video, or Home Video, including the rights to the images, the text, sound, still, all the elements that are or may be included in the content. Home Video may or may not have all of these rights. The parties will have to negotiate the parameters of the rights themselves and the responsibility for confirming this. So it may be through the contract terms that Conduit.com insists that Home Video clears the rights to all the content. So if you have a home video that has the matrix in the background, then maybe it's Home Video that has to go to the studio and clears the fact, it still clears the use of that content in the background. Part of the information that Conduit.com will generate to its business and collect are transaction records. For instance, content-specific buy rates, aggregate information about the exploitation of home video's content, and personal information. The parties will have to establish parameters governing home video's rights to see and use that information. And this gets into the privacy issue, but also gets into the issue of whether or not Conduit.com and businesses like that want to have the suppliers be too knowledgeable or very knowledgeable about their business. You don't want to give enough information to your supplier so they can say, I can do this, that way I keep it myself, and create your own competition. Assuming that Home Video, your client, will be paid some percentage of the revenue, the parties need to agree upon the splits and the models. For example, the revenue could be generated from advertising on the web page where users access the content. Or users could pay for each use and each viewing of the content. They also could pay to have access to all 4 categories of the content. Or basically perhaps subscription fee that they pay to have access to all of the content provided by my client. What about e-commerce opportunities? What does home video require advance payment prior to providing the content? It may be that you take the advance payment and then that money is increased against money is generated through the other models. That's something that needs to be negotiated. Of course, Conduit.com wants exclusive use of your client's content. Conversely, I assume that you want category exclusivity of your client's content on my client's website. We're going to have to work that out. Being mindful of the rapid proliferation of technology, you want to limit this agreement to the technology that Conduit.com is already using. And you also want to limit it to the territories where Conduit.com is already doing business. I, on the other hand, want to go out the box and try to get rights such that I can use it with any technology now, or in the future. And I also want the ability for my client to expand to different territories without having to come back to your business client and get permission to go to Mexico or Europe or Canada. As mentioned before, we need to discuss the technical aspects of the operation. How will Conduit.com receive the content? For instance, will it retrieve it from home video service? Also, which of our clients will be involved with third parties regarding other issues? For example, if part of my business structure is to sell ads on my website in connection with your content, does home video want to try to be involved in that business also, because they may have relationships with possible advertisers? That's something you have to think about when you have to address that kind of deal. With regard to Lesson 1, I've changed my ways. Now, on behalf of Conduit.com, I do not generally look to representations regarding infringement and rights as the end-all be-all. It has concerned me that the discovery of a problem here would automatically start the commencement of a cure period countdown. This clock typically puts the agreement in jeopardy with a short time frame of usually 30 days. And what I'm talking about here is when you put in language in record more in terms of the rights that you're getting or in terms of the technology and the problem, and your client says my client has notice of breach, then usually based on the termination clause, I have 30 days to cure it, or you can terminate the contract. That may not be enough time. And on the flip side of that, if your client provides you with some footage that has a problem with it because of a rights issue, it may take more than 30 days for your client to clear those rights. So I would propose, instead of having the Section 1 try to govern those types of rights, putting language about those rights in the identification. From my client standpoint, I don't really care how long it takes you to clear the rights, as long as you clear it, and as long as it has no negative impact on my business livelihood. And from your standpoint, your client's standpoint, I would hope that it doesn't take, it's not a concern that something has to be fixed in terms of in 30 days. For instance, if John client comes to me and says, I have this patent that covers your technology, I would hope that you would understand and we would not put the whole transaction in jeopardy while I'm taking the 6 months to take to negotiate a license. With the privacy changes coming, it is essential to be as clear as possible regarding the rights of the users and the rights of both of our clients. So if you're going to have some type of opt-in so that the client can say, I want to have more information from home video, so I can contact them directly if I like their content, then that should be negotiated. Otherwise, home video may get into the deal thinking they're going to get a lead, and they won't have it. The other thing that you need to think about, or we need to think about, is confidentiality, and information that is confidential, and how that is protected before, during, and after the operation of the two parties together. Moreover, we need to consider what may happen if one of both parties ceases to do business. And insurance is a very sticky subject because a lot of insurance companies still don't feel that comfortable with this type of business and this type of transaction because of the rights issues and because of the technology. But that doesn't mean that it's not something that needs to be explored by both parties to understand if the home video has coverage in case there is a clearance problem, or if Conduit.com has a problem, if there is a technology information problem. And then, of course, there's the miscellaneous legalese that goes in the back that I'm not even going to get into. So hopefully that gives you kind of a sense of where someone like me sits and things when we're going to deal with someone in the area of fraud and
Thank you very much. We have one more speaker, and that is my friend Renee, who is really next to speak to us about business aspects of this.
Stand up and reach the age where I was without my reading glasses about the right focal point from me. We tried to spread the needle a little bit, but Susan asked me to cover this range of topics, and that's impossible to the time frame. But I'm going to try to sort of hip-hop and go between business issues and some of the regulatory context in which those fit. In terms of clearing rights, it's an interesting issue. In the last 8 years of my professional life, I focused on the business issue side of it. But before that, I spent about 10 years first working at the Motion Picture Association and then at NBA Properties, setting up a worldwide anti-piracy program principally focused on video and television, cable, the type rights and their protection around the world from motion picture studios and television companies. And in today's world, I don't envy what the innovation has to face because to deal with online and digital type of problems on a global basis, it needs the facility with which they are transgressed. It was a challenge certainly that was far more significant than I had to face when it was simply dealing with satellite signals or the unencrypted footprint of the HBO signals or the Caribbean basin. But in today's world, I guess you have to look at rights clearances in that perspective from a number of points of view, starting with issues like what kind of content are we putting out over the internet. This roughly parses out into things like use of people's names and images, use of actual video content of some sort or another, whether it's streaming or still photography. And it also gets into the audio area of music, voice rights, and things of that sort. The right of publicity, just to start off with that, is something that is, at least in New York State, sounds in the Civil Rights Act. It goes back to the early part of the 20th century. It's a statutory creature. There are also common law type rights in other states. Roughly half of the states of the United States, 25-30, have state statutes, probably some of the most rigorous ones in terms of protection of people's names and likenesses and personas and lookalikes and voice-alikes and whatever are found in places like Indiana and California. The materials, the handout that I had on this, look at on 2 sites for that as well as some articles on the subject. The jurisdiction and choice of law is an interesting issue. Among other things, representing somebody whose name or likeness has been taken. One of the questions is, first of all, is it a living person? Is it or not? In New York State, for example, the civil rights law, the right to receive the right to protect your name and likeness is generally not extendable. There are certain things you can do during your lifetime to create a right by merchandising it and creating certain trademark or brand rights in it. But in the absence of having done that, you can run into difficult things. I had a case in the Southern District a couple of years back where somebody had gone up to the Schoenberg Library in Harlem and taken a picture of the Harlem Renaissance, which is one of the 5 all-black basketball teams. So it was a precursor to the ABA or the NBA, and they taken the 8 members of that team from back in the 30s, put them on a poster with their corporate logo, and they were handing those out as part of the promotional thing where they were doing certain vintage reviving their brand. They claimed that that was a non-infringing right, and we represented 3 of the widows and children of those players, and the one living player who was actually featured in that. And there were some interesting issues that came out. The case is ultimately settled, but it's the sort of thing that plays out a lot on the internet in terms of name and likeness rights. There are a number of cases that have involved taking people's voices, or even things that when you take Woody Allen's image, for example, and you have something that looks like Woody Allen, it isn't really Woody Allen, and is that an infringement of his right? Or one court at least said that yes, that was. But the use of the name, your name or your likeness, and your rights in that is a hot area that can come up a lot in the domain name area, particularly. And I guess one of the issues that must always be remembered in this is that we tend to be somewhat legally ethnocentric in terms of how we focus on law and its practice. It's frequently been said in the business world that you should think globally and act locally. When you're dealing with the internet world, you really have to think globally, act locally, nationally, regionally, and every other way, and you cannot forget the fact that once you go out streaming or in any other way someone can access the website, you're into the world. And that's one of the reasons why the World Trade Organization and a number of other different governmental groups, in addition to our own government in Washington, have been creating a number of multilateral treaties. And I'll get to probably one of the most important ones in the content area, the Digital Money and Copyright Act. But it is replicated on the international level by the Uruguay Round type progeny over in Geneva. Getting beyond the name and likeness sorts of issues, I guess if you get into film, video, music, in terms of clearances, what you have to go through if you're operating a website or you're trying to be respectful of intellectual property and proprietary rights. Some of these rights break down in things like, is it pre-existing content, or has it been created out of issue for a particular website in the first instance? If it's pre-existing content, you have to determine who holds the rights in it. And if you're dealing in the music area, for example, there are places such as the Harry Fox Agency and ASCAP and BMI and others who have either already asserted jurisdiction or in the process of asserting jurisdiction over usage in the internet online world. But you have to, first of all, figure out where you go. And sometimes that's not easy, particularly if these are not rights that are represented on a collective basis, the way that ASCAP and BMI to the current rights area. In addition, you have to deal with questions such as in new content, if you're creating it, what are the ways you go about doing that? Do you either do it on a work-for-hire basis? There are certain categories of works that are protected. Not every type of work is covered by work-for-hire protection under the U.S. law. There are enumerated 9 specific categories. There was another one that the music industry slipped in, and it was just slipped out in the past session of Congress. But if it's not a work for hire, when you created it as sort of the right from the beginning, you either have to obtain an assignment, or you have to have some sort of license to the right to clear those rights and to use those. One of the things that's important to remember also in dealing with the clearance of rights is that there are a number of guilds in the world. There are music guilds, there are guilds that protect the rights of actors and writers, and some of which have already asserted jurisdiction over the internet, and many of them have not. The Screen Actors Guild just created a special interim agreement to sort of voluntarily usable by producers, not mandatory, but they just finished a long strike this past year dealing strictly in the commercials area, the advertising area, and now it's settled around Labor Day. But there's another one that's moving on the horizon with Screen Actors Guild, and one of the things that's front and center, at least on their agenda, judging by what's been announced publicly, is the issue of asserting rights for the Screen Actors Guild and their members and AFTRA in that context over internet-type productions, the use of their members on the internet. You need to remember writers also, that will also be like they may be striking this coming year in terms of clearing rights for the guilds that way, or at least being aware of them. All of these guilds, you can go to their websites and you can download licenses in the same way that if you want to clear rights to music, you go to the Harry Fox Agency, which is connected to the National Music Publishers Association. They have an internet-type license. They have applications that you can fill out. You do know where to go with that. Similarly, ASCAP and EMI and CSAC, all of which are linked into the Harry Fox Agency in terms of hyperlinks. You can go and find their licenses and their rights there. What kind of licenses can you do when you're dealing with new sorts of things, particularly in the new medium? One of the things that's difficult in setting this up is not strangling the baby before it's actually had economic worth and vitality in the marketplace. There are per-use type licenses, there are per-page view type licenses, flat fees, revenue sharing, cross-promotional type licenses. People simply, I'll link my site to your site, we'll have our ads, we each keep our own revenue streams from those banner ads or whatever it is, or we share and work out a scheme that way. Equity type relationships are probably less common in 2001 than it was in 2004 because of what's happened in the NASDAQ and the stock market and the technology sector. Barter relationships where people trade off goods and whatever. These are all sort of different kinds of clearances and different sorts of models that are being experimented with. One of the regulatory things also that was touched upon is the whole area of privacy. Not the right of privacy in terms of protecting the likeness, but the area of protecting the privacy of the user of the site. Everyone has gone to the site, usually traditionally at the bottom of the home page with their access to the site. You'll find a terms and conditions of use, and you'll probably find a privacy agreement that's highlighted that you go through there. Sometimes they're combined. There are a number of resources that are out there, and I'm just going to pass over those quickly. It's probably the hot button, not only in the United States, but globally, in terms of protection of privacy rights. So they're assiduously protected in the European Union. In fact, transborder communication of data about users, particularly in the e-commerce area, where you're trying to measure the impact of ads and whatever. That's something that you to be very aware that there's a large global oversight mechanism in place there, and it's not just in the United States. If you go to the Electronic Foundation, Frontier Foundation site, which is the World Wide Web, EFF.org, or the Direct Marketing Association's site, that's THE-DMA.org, or one of probably the best things to be aware of also is FTC.gov. In the latter, you can come up with what is, again, probably the hottest button, at least in the United States, which is the Children's Online Privacy Protection Act, or COPA, as it's known, is aimed at protecting children ages 13 and under. And at that site, they have some fairly user-friendly type of materials that guide you through what you need to do to be compliant with COPA. I mentioned earlier the Digital Millennium Copyright Act. One of the things in terms of clearing music to be aware of is that there, as of several years ago, where the recordings of music were not traditionally protected for performance right purposes, they were protected by copyright as against reproduction, hard copy type of reproduction. In the past, there was a new performance right that was created because of all the problems of Napster, MP3, and the downloading era. And so there are now two things of clearing rights that you need to be aware of. There's the sort of brand rights that deal with the music compositions, the lyrics and the music that underlie music, and there's a second for the performance itself. So if you take a well-known performer or not well-known performer, band or whatever, and you could take that music and you put it into the digital medium, and you put it out over the internet, or indeed convey it off of a closed internet on-premises type of usage, you're into the Digital Millennium Copyright Act, and you need to know you have to clear two types of copyright now. rationale. One, in the performance itself, as well as in the underlying rights in the music and the lyrics that are there with it. One of the perspectives, I think, that, in terms of just winding up on the governmental side of it, is how you see both sides of the issue. And work both with the people who presently do it and the past with both the clearance side of this, as well as the people who are trying to go out and actually police the market and deal with the enforcement side of it. The Constitution and the creation of the right of copyright protection was created as an incentive to authors and inventors to go out and have a reward for the time and effort in to create. But one of the things that also occurs when you have a monopoly like this, and I think that MP3 and the Napster case have shown the tension between the marketplace and technology and what consumers want, and the vested interest and structure of studios and music recording companies and whatever. What happened, if you watched and followed those cases over the last couple of years, is essentially the RIAA and the companies have gone and they basically tried to put both Napster and MP3 out of business. The one in one instance, they sort of one in one instance went up on appeal, it was mentioned before. But what happened after that was essentially because the BMG, for example, had tried to do online interactive type of services, that it actually shut down its interactive division. What happened was they basically settled the lawsuit. All of the recording companies, they created a licensing structure. They went into the business with the same people who they had sued as defendants. In the larger perspective, one of the issues that on the policy level and the regulatory level is the question of how the interplay, whether it's in the U.S. Congress or whether it's in the World Trade Organization or the Intellectual Property Organization in Geneva, is how this all plays together with that incentive under our Constitution and the balancing of the public policy issues. And that's a lot of what we're seeing sort of play out in the courts in the legislature today.
Thank you very much. We're going to turn to the public discussion of these issues, but before we do, we need to change the tape.